Hello everyone, and welcome to this last webinar of this year by REACH Law. And today we'll focus on the Ukrainian law on chemical safety and how it relates to Ukraine REACH, Ukraine CLP, and special provisions that it also defines. So today we have two presenters, experts. So Olesja, do you want to present yourself, please?
Yes, hello everyone. My name is Olesja Winterberg. I'm Global Accounts Lead and Legal Advisor at REACH Law. I've been with the company since 2010, working with different chemicals regulations, from EU REACH to other global REACH-like regulations. And the moment I'm very much focused on the Ukraine chemicals legislation, Ukraine law on chemical safety, Ukraine REACH and Ukraine CLP. And I'm a lawyer by my background and originally Ukrainian, so I'm actually the one who's able to read all the legal text in the regional language. Thank you.
Thank you, Olesja. I'm Fredrik Johansson. I'm just a mere Finn. Don't speak Ukrainian, unfortunately, but thankfully we have Olesja. I'm a partner at REACH Law, head of sales. I have a chemical engineering background. I've been working with chemical regulations for 2 decades more. Time flies. Happy to be in this webinar, and of course I'm also focusing on new business developments such as Ukraine REACH, CLP, and the law on chemical safety that we'll talk about today. So the content, we'll give the quick customary REACH law in brief, and then Olesja will talk about the chemical safety legislation, or generally about the chemical safety legislation in Ukraine, then give an introduction to the law of chemical safety, give some key provisions, and after that I'll go into the permits that are defined, required according to this LCS. And then we'll do some conclusions and end with the Q&A, and we'll try now in earnest to keep this at 1 hour, because I have a hard stop more or less at 2 o'clock Finland time. So we'll go through things rather briskly, I think, hopefully. So, REACH law in brief. What do we do? Who are we? Where are we? So we provide support for REACH and REACH-like chemical regulations globally. So now it also covers Ukraine REACH, CLP, and this law on chemical safety that we are talking about today. So we have an office in Kyiv in Ukraine for these support purposes, and through this office also providing only representative services. So our head office is here in Finland, in Helsinki, but otherwise we have for all the other REACH-like chemical regulations, or most of them I would say, we have offices in these jurisdictions. So UK, for UK REACH in Manchester, then in Istanbul for Turkey KKDA, KNCA, so the CLP implementation there, and then also in Seoul, in South Korea for K-REACH and K-OSHA purposes, GHS purposes, and then also 2 offices now in India. So one in New Delhi and the other one in Mumbai, where we provide support for all these chemical regulations locally, and then of course also for India-specific requirements such as this India BIS, which we have also recordings on YouTube. So if you want to knock yourself out with that, then head over to YouTube. As far as services goes, today just focusing on what we do for Ukraine. So we provide a full set of the services that are required for chemical companies placing their products on the Ukrainian market. So this covers the Ukraine REACH regulation, only representation, registration, pre-registration, all that's needed, as well as then for CLP, of course, notification according to this to the CLP requirements and labels, and then this, for example, this alternative chemical name notification that we're talking about today, which interacts with the law on chemical safety, as we will see. And also, of course, this toxic chemical substance permit application, which we will be talking about today, which is something really special and something that we don't have in the EU, for example, or any of these REACH-like jurisdictions we looked at in the previous slide. And then also we'll look at, we can also provide services for Ukraine REACH authorization when that becomes applicable. And many more services. So essentially anything you need for Ukraine chemical regulatory compliance, we can do it. And we're happy to support you with that, of course. And just to remind you that we have a YouTube channel called Reach Law Talks. This webinar will be uploaded to YouTube also within a couple of days, so you will find us there at any time. And of course, we have quite a lot of content, so please feel free to head over to YouTube. Feel free to subscribe. We very much appreciate that. Try to get over the 1,000 subscriber thresholds. Did you know that you can also link your company email to a Google account so that you can subscribe using your company email? If you didn't, just Google that, and you can make the subscriptions even easier if you don't want to subscribe with your personal email address. Okay, the final disclaimer, copyright. So of course, all the content in this presentation is for general purposes only and does not substitute real consultancy and professional expertise. So if you have any issues on that, or I mean any particular specific issues pertaining to these compliance requirements, feel free to contact us directly. So based on this presentation, if you take any actions, then of course it's your own responsibilities. So we are washing our hands of any liabilities in this remark. And also note the copyright notice. And with that, just wanted to make also a slight disclaimer that some of the aspects for Ukraine REACH, CLP, and also the LCS, there are some unclarities, if you will. So this presentation represents the current level of knowledge, and it will be refined as more information becomes available. So stay tuned, stay subscribed to our newsletter. You will hear it there first. And with that, Olesia, please take over and let me know when to change slides.
Thank you, Frederick. So now we will discuss basics of the chemical safety legislations in Ukraine and what kind of changes have happened to this legislation in the last few years. Next slide, please. So the Ukrainian chemicals legislation and in terms of safety and management of chemical products have undergone quite significant changes, especially in the last few years. And the big change happened with the approval of the law on chemical safety, and the full name is the Law on Ensuring Chemical Safety and Management of Chemical Products, which we briefly refer to as the Law on Chemical Safety, or Ukraine REACH. And this happened in 2022. So basically, this is when the big changes in the chemicals legislations in Ukraine have started. So the law on chemical safety, it holds the ultimate authority over all chemical safety related matters on the territory of Ukraine. And it had set a so-called regulatory domain, a framework for the implementation of Ukraine REACH and Ukraine CLP. And as a result of the approval of the law on chemical safety, the regulations on classification, labeling of and packaging of chemical products, which is a Ukraine CLP, and technical regulation on safety of chemical products, which is Ukraine REACH, have been also approved. And CLP has been already implemented, and Ukraine REACH is going to be implemented very soon, and more information on the next slide. Next slide, please. So the focus of today will be the law on chemical safety, and it has been approved on the 1st of December 2022. So this is when this big change has happened to the Ukrainian chemicals legislation. And this is a law approved by the Parliament of Ukraine. And from the approval date, there was an 18 months, transitional period. So it means that the law has been enforced from 29th of June 2024. So this is something that is already in force. As a result of the approval and the entry into force of the law on chemical safety, the technical regulation on classification, labeling and packaging of chemical products, Ukraine CLP, has been also approved in May 2024 and entered into force 6 months later. So it's been in force since 15 November 2024. So we have law on chemical safety that is already in force, and we have Ukraine CLP that is already in force. Now, Ukraine REACH, it has been approved a little bit after the law on chemical safety entered into force, and it will be entering into force on the 26th of January 2025. So again, 6 months from the approval date. So we have Ukraine law on chemical safety and CLP that are in force, and Ukraine REACH is coming into force a little bit later next year. Next slide, please. So why a law on chemical safety was needed? So before the law on chemical safety was approved, there was no unified chemical safety system in Ukraine. So different matters in terms of chemical safety were governed by different sectoral legislative acts, and there was no centralized system to manage chemical risks in terms of production, use, storage, import, and disposal of chemical products. And law on chemical safety, it solves exactly this problem and governs all the stages of the chemical products from production to disposal. Then the second reason why it was needed is because, of course, Ukraine has aspirations towards alignment of its legislation with the European Union, and because it wants to become a member of the European Union. And therefore, the EU REACH and EU CLP regulations were supposed to be implemented in Ukraine. And to do so, the law on chemical safety was required because technical regulations in Ukraine by the legal system as established there could not exist on their own. So a law on chemical safety was introduced as the basis for these technical regulations. And then there were certain regulatory gaps in terms of international conventions and their implementation. And law on chemical safety also solves that. So it's also implementing the Stockholm, Rotterdam, and Minamata conventions. Next slide, please. So let's now talk about the basics of the Ukraine law on chemical safety. Next slide, please. So as said, this law is already in force since 29th of June 2024. This is a law, not a technical regulation, and because 18 months of the transitional provisions have already passed, essentially most of the requirements of the law of chemical safety already apply. The law is available only in the Ukrainian language, and likely no English version will be ever provided. And the competent authority for this law is the Ministry of Environmental Protection and Natural Resources of Ukraine, which we call the Ministry of Environment. This is the same competent authority as for the Ukraine REACH and Ukraine CLP. Next slide, please. In terms of the structure of the law, it has 12 sections, and the most important ones that you can see on the left side of the slide, so from section 1 to section 5. So we have general provisions, basically containing definitions, objectives, principles, and roles of different stakeholders. In the section 2, we have the responsibility of the government, ministries, and etc., etc. In the section 2, we have matters in terms of ensuring the chemical safety. And the most important article here in relation to Ukraine REACH would be the chemical safety assessment, and the it's Article 25, the requirement of the CSR for chemicals that are placed on the market in 10 tons or more. Then the two most important sections of this legislation in terms of Ukraine REACH and CLP is the section 4, which is the requirement for production and use of chemical products. It specifies the classification, labeling requirements, talks about on the representative role, requirements for the manufacturers, obligations of the manufacturers and importers, etc., etc. So it lays down the main requirements of the essentially Ukraine REACH and Ukraine CLP, and the Ukraine REACH and CLP further open up those requirements. And then we have section 5, the permit system, which my colleague Frederick will be covering in more detail later in this presentation. Next slide, please. In addition to Ukraine law on chemical safety and Ukraine REACH and Ukraine CLP, we have different orders and other regulatory acts that are well embedded in the text of the Ukraine law on chemical safety. So this law contains different references to different orders on different administrative matters related to the law on chemical safety. And for example, when the order on either of these matters is approved, you could see that it's highlighted in the blue text within the text of the law itself. For example, on this slide, you could see the Article 39 about the State Register of Chemical Substances in Ukraine. So the order on the management of the State Register of Chemical Substances in Ukraine has been already approved, and you can see it's in the blue color in the text of the law. So you could click on it. Basically, it's a link and read the order separately. Of course, it will be in Ukrainian. So there are different orders and regulatory acts, and some examples would be the order and procedure of registration of the notification of the use of alternative chemical name, and my colleague Frederick will talk about this later in this presentation. For example, there is another order on procedure of creation and administration of chemical safety information system, and basically talks about the creation of an IT system for the chemical safety, which you will use for submission of your registration dossier and other matters under Ukraine REACH and CLP, but unfortunately it doesn't say when this safety information system will be available. And for example, another good example of such order would be a procedure for forming and maintaining the list of dual-use chemicals. And this is something, again, different from other regulations. So there will be a separate list maintained by the Ministry of Environment that would contain the dual-use chemicals, and it would also contain specific limits. So if you are placing on the market substances above those limits, you would need to make a notification to the security service of Ukraine. So there will be a separate procedure for this requirement. And of course, future regulatory acts and orders, they will be highlighted in a blue color in a similar way as those that already are approved. So more orders and regulatory acts are coming. So all in all, the Ukraine law on chemical safety is much bigger, in fact, than it is when you try to read it, because it contains quite a lot of different regulatory acts that are relevant for the interpretation and the implementation of the law itself. Next slide, please. According to the law on chemical safety, the Ministry of Environment has to maintain quite a lot of different registers and lists. But let's look at the most important ones in terms of Ukraine REACH and CLP. So the Ministry of Environment will have to maintain the State Register of Chemical Substances. It's a similar register as ECHA has the dissemination tool. So this order on the creation and management of this register of chemical substances we have just discussed on the previous slide. There will be also a register of classification and labeling of chemicals. This will be created on the basis of the CLP notifications submitted according to the Ukraine CLP. Then there will be a list subject to market phase-out. Basically, this is already an existing list, and this is Annex 14 of the Ukraine REACH. And at the moment is the same in terms of the entries as the EU REACH Annex 14, and more information on this coming by Frederick later on. Then we will have a list of toxic substances. This is something that is not in the EU REACH and is very unique to Ukraine REACH and Ukraine law on chemical safety. So there will be a list of the toxic substances meeting the criteria of toxic chemicals according to the Ukraine REACH. Then the list of dual-use chemicals that we have already discussed, containing the dual-use chemicals and their limits. Then there will be a list of substances of very high concern. Will this be the same as the EU REACH candidate list substances? It's unclear at the moment. It could be It could be, but it could be also that it would contain all identified substances of very high concern in Ukraine, identified on the basis of the submitted CLP notifications. This is something to be still verified. And as you can see, other different lists and registers to be maintained by the competent authority. Next slide, please. So we have already mentioned how the Ukraine LCS related to Ukraine REACH and Ukraine CLP, but to conclude, basically Ukraine law on chemical safety establishes the main principles for classification, labeling, packaging, registrations, different permitting, and Ukraine REACH and Ukraine CLP expand on those requirements, but at the same time, they mirror the requirements set out in the EU REACH and EU CLP. So the Ukraine LCS, it's a legal framework and it's a primary law, and it's a layer above the Ukraine REACH and Ukraine CLP because it is a law, and Ukraine REACH and Ukraine CLP are secondary to Ukraine law on chemical safety and are technical regulations. And of course, as mentioned, we have different orders and regulatory acts directly mentioned in the Ukraine law on chemical safety, and they are also under the law on chemical safety framework. Next slide, please. So now let's briefly look at the key provisions of the law on chemical safety. Next slide, please. So as said previously, we could say that the most important sections in the law on chemical safety in terms of their interconnectivity to the Ukraine REACH and CLP are sections 4 and section 5. So section 4 sets out the requirements for the production and use of chemical products. These are articles 35 to 46, and it sets out basic requirements for the classification, labeling, identification of chemical substances. It talks about state registration meaning registration under the Ukraine REACH. It talks about the formation of the register of chemical substances, and etc. So basically, these are the basic requirements of the Ukraine REACH and CLP set out in the law, and then Ukraine REACH and CLP, as said, is opening them up further. Next slide, please. We will just briefly look on the requirement towards the foreign manufacturer and only representative, how it is written in the law on chemical safety. So Article 40, paragraph 7 states that the foreign manufacturer can appoint the only representative that could fulfill the requirements for the importers outlined in paragraph 6 of the same Article 40. So Article 40, paragraph 6 outlines distinct 11 obligations of for the importer that could be performed by the only representative if such only representative is appointed by the foreign manufacturer. However, the condition for the importer to be exempt from its obligations under the law on chemical safety is basically coverage by the non-Ukrainian manufacturer from upstream to downstream. And paragraph 8 of the same Article 40 specifies this further. So basically, the importer doesn't have to provide safety data sheet, prepare a safety data sheet if it gets the safety data sheet from the only representative of the non-Ukrainian manufacturer. It could be also covered by a permit for the use of toxic chemicals, and etc. So the condition for the importer to be exempt is to be covered by the non-Ukrainian manufacturer through an only representative from upstream to downstream. Next slide, please. So let's look on those requirements and obligations that only representative can do on behalf of the non-Ukrainian manufacturer instead of the importers. So the only representative can identify chemical substances, classify, make chemical safety assessment, determine the uses, complete the registration, meaning the Ukraine REACH registration, obtain permits for the toxic chemical, permit for the substances listed in the Annex 14 of the Ukraine REACH, register a notification for the use of an alternative chemical name, which is different from the EU CLP. So basically, under the Ukraine CLP, this alternative name notification is also specified in the law of chemical safety, which allows the only representative to submit the alternative chemical name notification on behalf of the foreign manufacturer. The safety datasheet requirements and any other requirements, especially those related to the dual-use chemical substances. We have discussed earlier that there will be a register of dual-use chemical substances and their respective limits. Next slide, please. And slowly going to the permit requirements in Section 5. So this is another most important section of the law on chemical safety. It basically contains only 3 articles, but they are quite long and extensive. And these articles define the permits and the requirements for the permits in terms of authorization, notification of the alternative name, and unique to Ukraine, the requirement of the permit for the chemicals classified as toxic. And now my colleague Frederick will continue in more detail about those permits. Over to you, Frederick.
Thank you, Olesia. Okay, let's have a look at these different permits as per these articles 47, 48, and 49 in this law on chemical safety in Ukraine. So just a quick overview of the different orders governing these different permits. So at this point, we'll just talk about them generally as permits. I will define it a bit more as we go further along. So as Olesia mentioned, this Article 47 specifies this requirement for this permit for the use of this SVHC. So this is akin to authorization. We'll call it actually authorization going forward, but there is already an order covering this specific requirement. So it defines these procedural acts and provides additional details on the implementation of certain requirements under these articles. Then Article 48 specifies the requirement for this notification on the use of alternative chemical name. And this also has its separate order on the registration notification for the use of this alternate chemical substance name. And here you can see these are actually links in the presentation. We'll be sure to add those as links in YouTube, because obviously you can't click them in a video, at least not yet. And Article 49 then specifies this specific toxic chemical substance permit, and there is also the same order as for authorized substances already available. So this order on the issuance, refusal, reissue, and revocation of permits for use of toxic chemical substances. So this was just an overview of these orders. So now let's go into these 3 different. So this is Article 47, 48, and 49 on the screen, and we'll go through these one by one. So in the legal text, it talks about procedure for obtaining permit for chemicals being phased out of the market, as said, specified in Article 47 of this LCS. But in this presentation, and also generally, I think the more convenient and more useful and familiar term for us who have dabbled with the EU REACH and the other REACHes is authorization, because it links back to Ukraine REACH and Annex 14 defining the substances subject to authorization. So where it says permit in Article 47, we talk about authorization more generally. So these substances that are phased out from the market are indeed specified in this REACH Annex 14. It's not in the law of chemical safety. In this Annex 14, as we will see in the next slide, we also the legal text also defines this latest application date marked by LAD and the sunset date marked by SSD. And of course, they also identify the substances themselves. So by name and CAS number, as you will see. So this, when you submit the application for an authorization, we call it AFA more generally in this, let's say, within REACH law. Typically, we call it an AFA, but it also means the permit in this context. But we'll talk about an application for authorization here, and it contains more or less the same information that is required under EU REACH. There are certain differences, such as there is an additional requirement for liability insurance, and we'll see that in an upcoming slide. I will talk about that a bit more. But that is distinctly different from EU REACH, for example. So if an OR handles authorization applications, then this OR would, to our understanding, require this liability insurance. But we'll talk about that in a coming slide. And it's not just unique to this authorization. The latest application date is always 2 months before the sunset date. So it means that by this time, 2 months before the sunset date, you need to submit this application for authorization. And this is either then granted or rejected within 30 days of submission. So that's really quick process for accepting or rejecting, compared at least with EU REACH, where it can take years, as those who've been working with that knows very well. But it can only be made for a validity of max 5 years. So that's different from EU REACH, where it can be 5 years, 7 years, it can be 12 years, it can be even more in very specific cases. It can be shorter also. So when the applicant prepares the application for authorization, they seek a certain validity period between 6 months and 5 years, and then it's up to the authorities to whether they accept or reject that application for that validity. If for whatever reason it is not accepted, then you have to reapply, and of course either make your application better or then reduce the validity time, because those play a part in determining whether it can be accepted or not. And as Olesia already alluded to, owner representatives play a very important part here also, because they can also apply for an authorization. So that is very, very good to know. So if we look at the authorization list, this is Annex 14 of the Ukraine REACH. It's also in the EU, of course, Annex 14, and this has been fully integrated now under Ukraine REACH. So you will find under Annex 14 of the Ukraine REACH regulation 59 entries, and all of these with the latest application date of 1st of April 2027. So that's fairly soon, and the sunset date of 1st of June the same year. So 2 months after that, 2027. So only 2 months apart between latest application date and sunset date. That's quite extraordinary, but for under EU REACH, of course, it was significantly longer, like 1.5 years and so forth. But in this legal text, you will see these mentioned. So on the screen, you can see the name of the substance, CAS number, then you can see the latest application date and the sunset date. And if there are additional preconditions, you can find them also listed here. So if you look at the application itself, then those of you who worked with authorizations will find this very familiar, except for a few last lines. So of course, in the application, you need to define, of course, the substance identity, so name of the substance identifier, composition, concentration ranges, etc. And very important, of course, provide the identified uses subject to this authorization. It will likely use the same use descriptor system that we have under EU REACH, developed under EU REACH. Then, as I think Olesia already mentioned this, but also the chemical safety report plays, of course, a very important role. It will also need to be included, as well as a socioeconomic analysis, looking at the consequences, whether if an application is rejected versus approved, what are the socioeconomic outcomes in that specific geographical area and so forth. We'll not go into details here. Also, an analysis of alternatives as well as a substitution plan needs to be included. Then also, if there are any waivers or for information that is not considered in the authorization, you need to provide waivers and justifications, but that is a fairly small thing. But these need to be also included in the application. And what is curious is this point 8. You need to also include liability insurance information for the coverage of damages that may be caused to the environment, to life, health, and property of third parties during the use of the substance. So this is quite interesting and is a bit of a curveball when it comes to these requirements. So that's something that is distinctly different from, for example, EU REACH, because it's included here in the law specifically. And then also you need to provide information about the calculation of those fees, and we'll look at the fees in the next slides, which are can be quite significant, especially if you have higher tonnage band substances. So what is good to know, that currently there's a martial law in place in Ukraine. So this authorization requirement, so this aka permit, according to Article 47, is not required. But if there is a peace, then of course that is something we're all hoping for, and the martial law is lifted, then these requirements come into force. And for example, if that would happen in due time before these latest application dates, then those application dates would still apply according to the current legal text. So let's look at some of the fees. So when you are calculating your authorization fee, then you need to, again, as if you recall from watching our Ukraine REACH registration webinars and YouTube videos, you will see that we have this concept of the subsistence minimum. It's a minimum level of income, which is considered to be necessary to ensure sustenance and other basic personal needs, allowing people to essentially survive. So they take this subsistence minimum times different coefficients for different criteria. So for example, in this case, for authorization fees, you take the subsistence minimum, which is 2,920 hryvnia. Sorry for all Ukrainians there, my pronunciation is probably not good. It's around 67 euros according to the exchange rates from yesterday, today. So you take that times this coefficient, depending on duration of the authorization you're seeking. So if you are seeking a higher duration, of course, you will multiply the subsistence minimum several times more than if you just have a shorter one. The number of uses, and you have different number of uses and number of coefficients. Then you have number of substances if you are apply for authorization for several substances. Default is of course 1 and with 1 coefficient, but if you would be authorizing many substances at the same time, which is, I would say, fairly unlikely, you would be capped at the coefficient of 10. And then you also use the volume of the use for the duration of this or validity of the authorization, and you take that total volume for all these substances and uses and aggregate it and times that coefficient. So you can see if the tonnage band is high, then you get a quite significant multiplier here. So what this means is subsistence minimum times duration of the authorization coefficient, number of the uses of the substance coefficient times number of substances coefficients times volume of use coefficient. So long story short, I provided a few examples here just to show you how these fees aggregate. So in the first example, it's seeking a duration of 1 to 1.5 years. You have one use, one substance. Volume of use aggregated is only up to 1 ton. The fee will be very small. Then you seek higher validities for several uses, still one substance for higher tonnage bands, and it becomes bigger 10 times. Then you have for even longer durations, even more uses, but still just one substance. For even higher tonnage bands, and it starts going up almost exponentially. And then for the last one, for the highest tonnage band, for highest longest validity, for high number of uses, and it can be quite significant. I think for most companies this would probably not be applicable, but here it is nonetheless. Very expensive. I hope I got these calculations correct, but that's authorization for you under Ukraine REACH and the law on chemical safety. So next, let's go to Article 48, looking at this alternative chemical name notification requirements, what that means. And I'll need to speed up a bit. Okay, so just to give you an overview, of course, we're talking about Article 48 of the law on chemical safety. It talks about the notification of these alternative substance names, and it also ties into Ukraine CLP Article 75 that defines the alternative substance name provisions. Additionally, like for example, the EU CLP Article 24, so where it says about request for use of an alternative chemical name, and then it starts the manufacturer, importer, or downstream user of a substance in a mixture may submit a request to the agency to use an alternative chemical name, etc. So the purpose why you would be applying for this sort of an alternative chemical name and doing a notification thereof is typically to hide the identity of the substance in a mixture. Due to CBI confidentiality reasons, you don't want to disclose the full recipe of your mixture to clients due to confidentiality, IPR related issues, so intellectual property rights related issues. What is also important is that this Ukraine chemical safety law on chemical safety (LCS) allows the only representative on behalf of its non-Ukrainian manufacturer to submit this alternative substance name notification. That's it. That's different from EU CLP. So this is a very good, let's say, initiator of making it easier for companies to comply or take opportunity of this being outside of Ukraine. You have to have this alternative substance name notification accepted before you can include it then in the safety data sheets and labels where applicable. And the notification, when you submit it, takes 30 days again to review, and this once it's approved, it's granted for indefinitely until it could be cancelled, of course, by the authorities, so forth. So you don't have a validity phase or period for this notification. Good to know is that you cannot use this alternative chemical name notification. You can't do a notification for toxic substances, substances of very high concern, and then corrosive chemicals. So if you have any of those, you cannot notify. You can't seek for alternative substance name. So when you submit the application, what you provide is, of course, information about the chemical product containing the chemical substance, and then you provide information about that chemical product, trade name, classification, etc. But then you also, of course, have to provide information about the actual substance you're seeking this alternative chemical name for. So you provide details on substance identity, CAS numbers, EC numbers where applicable, also classification information, concentration, and then of course you give an alternative name for the substance to be used instead of the real name. So this one you can make up. Of course, you don't use any like trademarked names and etc. That's goes without saying. But you can make this substance name up, alternative substance name up. Then you also have to include justifications in this, a couple of justifications in this notification that if you apply this alternative name still in the safety data sheets, labels, and other guidance on safe use, you still need to make sure that workers can protect themselves and the public health is safeguarded, more or less. So it cannot be so that due to this, the risks are increasing. Beyond that, you also need to provide justifications that revealing this substances, confidential substances, actual name would then violate IPR rights, patented information, proprietary information, and if exposed, you would then it would result in actual harm to you by exposing this, for example, the recipe or the substance to your competitors, and it would have competitive disadvantage and so forth. And as with the previous and all these Article 47, 48, and 49 permits, you would also have to pay an authority fees for this substance or for this notification. And here we go. It's the same basic principle. You have a criteria, you have a coefficient, you have two criteria in this case only. In this case, you take the subsistence minimum times 5, which is around 330 euros at the moment, and you take that times company size times additional product names. So what this means in practice, just to give a few examples. Again, you have company size here. You have 1 to 5 products that you are seeking an alternative name notification for, or you're doing this notification, for example, through your only representative. You have small, medium, large, and then we have a 4th example for more products. So in this case, small company, it's only 167 euros at the moment. For medium, for 1 to 5 products, 250. Large company, 1 to 5 products, 334 euros. And the large company for 15 products, for example, then this would be around 500 euros. So very, very, let's say, reasonable fees here compared, for example, with the authorization fees. Albeit this is, of course, a completely different beast. Okay, let's go to the last one, which is the Article 49 toxic chemicals permit, which is, I think, the most exotic of these, because this is something that we don't have anything similar, for example, under EU REACH. So this is absolutely something additional and different. So in this law on chemical safety, a toxic chemical is mentioned as a hazardous substance that may cause acute or delayed severe poisoning, leading to illness, disruption of bodily system functions, or death if ingested, absorbed through the skin, or inhaled. So what these criteria, they're further defined under Ukraine REACH, Article 259. Here you can see it's jumping back and forth between these different regulations, where it defines these toxic substances as acute toxic category 1, 2, or 3, according, of course, to Ukraine CLP. Then STOT, single exposure category 1 or 2, and then STOT, repeated exposure category 1 and 2. For all these, a permit is required, and these are defined in this Article 49, more specifically 49.9 or 0.9 of this law on chemical safety. And again, permits are granted, rejected within 30 days of submission, and its validity is 3 years for all these applications. So if you look at the permit application, and give a bit of background also here. So legal entities that are manufacturing, so you manufacture or use these toxic chemical substances as defined, we just went through this, they need to obtain this permit for the use of this toxic chemical substance. And you have to apply it for each toxic chemical substance. And what is very important to understand, that if you have these sort of substances, you need to seek this permit, toxic chemicals permit, for any annual tonnages of this substance. So there are no tonnage thresholds. So the same for authorization. So that is very good to understand. So regardless of tonnage band, you need to apply if this applies to your chemical substances placed on the market in Ukraine or manufactured in Ukraine or used. So these, again, as with the normal but this authorization, you need to identify these uses, intended uses in this application. Without this permit, you cannot manufacture or place on the market or use substances. So what is curious at the moment is that, as Olesi already mentioned, this law of chemical safety is already in force, which indicates that these, if you have these toxic chemical substances, you might already require this permit as per now. Even though this entry into force of, for example, Ukraine REACH is not yet there, and Ukraine CLP has just entered into force. So that's quite interesting. And at the moment, based on current information, this one-year transitional, there was some discussion, some murmurs, if you will, about the one-year transitional phase for these chemicals to be applied that have been on the market before the entry into force of these Ukraine REACH and CLP, that it would have applied, but now it seems that it would likely not apply. And this is something that, of course, we are following quite closely. So we'll keep you up to date on that. You can only submit this application for your own specific uses, including manufacturing. So you can't like cover downstream users in this your own application. So in this sense, it is again a bit different than an authorization, because this, for authorizations, you can cover downstream users if they are covered in your authorization. But this toxic chemicals permit, it is only for you, and you have to, each and everyone who need to comply with this for their toxic chemical substances would need to then apply themselves. And the good news is that an only representative can apply for this permit on behalf of the non-Ukrainian manufacturer. So that is good to know. If we look at the application itself, fairly quickly here, as time is running out, you need to provide obviously substance information details. You need to again provide information about the uses of the substance as part of this application. So using the use descriptor system, most likely, a chemical safety report, whether it's only applicable to over 10-ton substances per annum. Toxic substances in this case will need to be determined. It may be that it is not, but this is something that we are following also very closely, and you need to, if you want to follow up on this, you need to follow us also on for example, LinkedIn and our newsletter and on YouTube. And of course, details on the implemented risk management measures so that you can use and yourself can use it under safe conditions. And again, like for the authorization, you need this liability insurance covering this, again, harm to the environment, life, death, property of third parties from the use of this toxic substance. And as with all of these, you need to pay a fee and you need to provide a calculation thereof in the application. And if we look at, again, the toxic chemicals permit fees, they're again set up the same way. So you take the subsistence minimum times, multiply it with a coefficient for certain criteria. In this case, we have 4, number of toxic chemical substances, volume of the use of these toxic chemical substances, and number of types of uses of toxic chemical substances. So you take this subsistence minimum times number of toxic substances coefficient times volume of use of toxic chemical substances coefficient times number of types of uses of toxic chemical substances coefficient. That's a mouthful, I think. Anyway, what it looks like in practice is as follows. Again, we have 4 examples. The one substance tonnage band, 1 ton per year, 1 type of use. The fees are negligible, authority fees. 2 to 3 substances at higher tonnage band, one use type, a bit more but still manageable. 6 to 10 substances, even higher volumes, more uses, higher but reasonable, I would say. Over 10 substances, highest tonnage band, over 3 types of use, the highest fees would be around 3,000. So very, very, I would say, reasonable in this case. of course, it adds up if you have a lot of these. Okay, with that, that was like a quick run through of all these 3 different permits. You heard it here first on our REACH Law webinar. Sorry, going back, now going forward to conclusions. So just a quick takeaways. This law on chemical safety has already been approved, and it's already entered into force June 29th, as Olesia talked about, as well as Ukraine REACH. It has been approved, but it's not yet entered into force. It will enter into force on 26th of January next year, and it will be closely aligned with EU REACH, starting with the pre-registration requirement for 1 year forward. So if you want to know more about Ukraine REACH, please head over to our YouTube channel, REACH Law Talks, and we have material there. The same goes for Ukraine CLP, except that it has already entered into force. It entered into force 15th of November, so roughly a month ago, and it's also closely aligned with the EU CLP. And if you want to know more about this, just go to our YouTube channel again and have a look at our content there on Ukraine CLP. As Olesia talked about, you need to look at this law on chemical safety in connection with both Ukraine REACH and Ukraine CLP. You have to look at all of these 3 to understand how they play together and what are the final requirements for companies and so forth. So that's very important to understand. And our recommendation for you who are wondering about, does these chemical regulations apply to you, then you need to ask yourself and identify the chemicals that you are placing on the Ukrainian market. You need to check, do we have these substances that are subject to Ukraine REACH pre-registration registration starting at 1 ton per year? I said, have a look at our specific content on that on YouTube, on REACH Law Talks. Then we have these toxic chemicals. They have no threshold. It was this permit under Article 49. Then we have substances subject to this authorization requirement. And once the martial law is lifted, then these will come into effect. For example, according to the current latest application date and sunset dates. And then you also need to make sure that if you have these CBI issues and you want to hide your substance name, then you can use this alternative name notification procedure we talked according to this Article 48 of the law on chemical safety. And then, of course, according to CLP, you have to, so Ukraine CLP, you have to notify hazardous substance regardless of the threshold. And this notification is already ongoing, and you have 1 year to do that for hazardous substances that have been on the market before they enter into force of Ukraine CLP. So it's already entered into force. So anyway, have a look at that video on our YouTube channel. Also, we have content there also more specific to that. And in any case, very important to understand that non-Ukrainian manufacturers and formulators, note, can appoint this only representative to take care of these import obligations under Ukraine law on chemical safety, as well as this Ukraine REACH and Ukraine CLP. All right, and now, hope you can still hear me. It says something about connectivity, but okay, we are soldiering on. So we're following all of these developments very closely. So make sure to follow us on LinkedIn, and also subscribe to our newsletter on our website, so reachlaw.fi, and of course, subscribe to our YouTube channel, REACH Law Talks. You can find these by Googling very easily. So now the questions and answers. And if I can ask Olesia to come back online, and I have a few questions. We'll take this quite quickly as we are almost going over time again. So we have a few pre-submitted questions. I'll take some of these, and then we'll take a few from the chat. And for the rest, please feel free to contact us directly if you have something, some specific questions, or we didn't answer your questions. So starting with the first one, Olesia, are you ready? Is it correct that substances introduced in Ukraine from November 15th this year must be notified within 30 days of the first placement. Yes or no? So this is under Ukraine CLP.
Yes, this is correct. So you need to notify, and you have 30 days for the CLP notification.
Very good, thank you. And I'm just shooting this really quickly. Is there a volume limit related to the permit required for toxic chemicals? I can take this one. So no, as we discussed in the presentation, no thresholds. There are exemptions, but no thresholds. Question on toxic chemicals permit. Can a non-Ukrainian manufacturer appoint an Ukrainian only representative to get the toxic chemicals permit for a substance? If so, will this cover a non-Ukrainian formulator using the substance in a mixture and sending this to Ukraine?
Yes, it is possible to appoint an only representative, but then you would need to consider the uses. So what kind of uses are in Ukraine to cover your users in Ukraine? So that's important.
Yes, thank you. I can take the next one. So there's a question on pre-registration. If a non-Ukrainian manufacturer appoints an OR, an only representative who pre-registers substance, can this pre-registration cover indirect import of the substance by the customer? Yes. The only representative just has to know who those customers subject to indirect import are so that they can cover them and their volumes. Very important. So the same applies for all these other EU REACH and UK REACH and Turkey, KKD, IK, and so forth. The same applies. Will the law on chemical, so next question, will the law on chemical safety also apply to pesticides, or will they be exempted?
So the pesticides are not in scope of the Ukraine law on chemical safety or the Ukraine REACH or Ukraine CLP.
Yeah, thank you. I guess there are some also more specific questions, but I asked the person who sent this question, please, if you can contact us directly by email. You will see our contact details at the end. Do we need an OR agreement when we are a foreign manufacturer? And if yes, how do we arrange this? Okay, so I can take this. So please just contact REACH Law. We'll be happy to set that up and tell you exactly how that is done. Very simple. Just contact us at sales@reachlaw.fi or the contact details you will see in just a second. You will also find all our contact details on our web pages. Okay, I'll take a few from the chat. There's a lot of questions. Hello, list 5 is concerned by the permit obligation. So this is toxic permit, chemical permit. So yes, I'll take that, Olesia, quickly. So permit, again, a question on permit has to permit Article 49. So this toxic chemicals permit has to be requested, submitted by user in Ukraine. So it's the Ukrainian manufacturer, user, or then an only representative. So yes, you can't do that from outside except through an only representative based in Ukraine. Olesia, please feel free to chime in if something is, I'm missing something. If a substance has an authorization in the EU under EU REACH, is additional authorization under Ukraine REACH to be required? Yes, because it's different jurisdiction, different regulation, so it is additional. Of course, you can utilize the information that you prepared for your EU REACH authorization. You can use it for Ukraine also, but it is not like automatically recognized or anything like that. Has this authorization something to do with the toxic substance permit? So these are different requirements, albeit a bit of overlap in a sense. Does Ukraine REACH also have a restriction list like Annex 17 under EU REACH? So yes, they took the restrictions from EU REACH. Was it, Olesia, by end that was implemented under EU REACH by end of like last year, and that those have been included under Ukraine REACH? Was it so?
Yes, it is so. However, like if you want to really be sure, you need to look entry by entry, because there are minor, but some differences are there that are related both to translation and then certain specific regulatory procedures on the territory of Ukraine. So essentially, yes, it's almost the same, but please check entry by entry.
Yes, very good. And then we have, I'll take two quick ones. What is the delay to pre-register substances, different tonnage bands to consider? I'll let you, Olesia, speak. Go ahead, please.
Well, but there is no essentially like delay to pre-register substances. So the pre-registration for substances will start from the 26th of January 2025 and will last for 1 year. And of course, I mean, if you have been placing the chemicals on the market before Ukraine REACH entered into force, so before 26th of January 2025, you do have 1 year to pre-register, so you don't have to do it immediately. However, if you look at the registration deadlines currently set by the resolution of the implementation of Ukraine REACH, you could see that the first registration deadline is coming very close to the pre-registration deadline. So from that perspective, we suggest not to delay the pre-registration and do it, well, preferably maybe in the first half of the 2025 to be ready to start the pre-sieve communications and eventually proceed with the registration. And there is no tonnage band difference, well, for the pre-registration in terms of the deadlines. It's the same deadline for the pre-registration for all tonnage bands, but then registrations are staggered depending on the tonnage bands.
Thank you, Olesia. And again, I recommend you have a look at our content on our YouTube channel, REACH Law Talks, specifically on the registration and pre-registration. You will find your answers there in more detail. Next to last question, must the CLP notification be submitted by the Ukraine OR for the non-Ukrainian manufacturer, or is it for the importers? So this we have some new information. Leslie, I'll let you take this one also.
Yes, so if you, of course, read the Ukraine CLP, there is no such option. There is no OR role in the Ukraine CLP or in the EU CLP. However, as we have shown you on the slides related to the obligations of the importer that could be performed by the only representative on behalf of the non-Ukrainian manufacturer, you could interpret from there that the Ukraine CLP notification might be also possible for submission by the Ukraine only representative, because it allows for the submission of the alternative substance name. So why not also the CLP notification? But it is yet to be confirmed by the competent authorities, so it's not 100% true. So we are still waiting for further confirmation from the competent authority. But even if that won't be possible, then the only representative in Ukraine can be a coordinator of the group notification of the importers in Ukraine. So that would be like the option number 2. However, we are still waiting and hoping that Ukraine REACH only representative would be able to just submit on behalf of the non-Ukrainian manufacturer CLP notification as well. Thank you. Thank you,
Leslie. And a quick last question. If Ukraine joins the EU, what happens to the law of chemical safety?
Well, at least the Ukraine REACH and Ukraine CLP won't be valid anymore, because it will be EU REACH and EU CLP for Ukraine. However, likely the Ukraine law on chemical safety will remain, because it covers, as you have understood from this presentation, much more than only Ukraine REACH and Ukraine CLP. So, for example, the toxic chemicals permit will likely stay forever, so we can't get rid of it because it's specifically mentioned in the law of chemical safety. So likely it will stay and will continue to be enforced, probably with certain amendments, but as such, no big changes are expected.
Very good. Thank you, and thank you for the questions. If we did not answer your questions, please just drop us an email directly. We're happy to answer those questions. So, in any case, of course, thank you very much for attending this webinar, and feel free to reach out for help with all these regulations. So Ukraine REACH, Ukraine CLP, Ukraine law, chemical safety, support. We're of course very happy to help in any and all cases, most of the cases of course. Won't promise in all cases. Anyway, we do our best. So with that, you will see our contact details on the slide. So thank you very much for your attention. Thank you, Olesia, for co-hosting this. And of course, thank you all for attending, and I wish you a very happy holidays, seasonal greetings, and of course, Happy New Year 2025. Thank you, and
Thank you.
stay safe. Bye-bye.
Thank you. Bye.